Hi, we got a little burst of music there for a second. Hi, everyone. Thanks for being here. Welcome back to our Tuesday webinar where we share interesting legal updates and other content for all of you. So thanks for being here, especially during a holiday week. I know a lot of people are probably not going to be here today, but let's get on with the agenda. Today we have four presenters. We're going to start with Nick Jacobson, who is it says associate there on his slide that's coming up, but I know that he's actually a member of our Rochester office who will give us a litigation update. Nick's going to be a regular moving forward this year with more litigation updates. We're gonna get Nick back here on a semi-regular basis to let us know what interesting cases have been decided that might impact you. So thanks, Nick, for doing that. Today he's going to talk about a significant Supreme Court case that we've recently heard about. In the popular news, actually. I was at a party over the weekend and I had a non-lawyer friend come up to me and say, "What's this I hear this decision that's like important about, I don't know, agencies?" And I said, "Oh my gosh, I can't believe people who are not lawyers are talking about this," but it really is a big deal, this case overturning Chevron. So Nick's going to talk about that as well as another case related to the standard for imputing liability for harassment to employers, really something that we watch very, very closely. After Nick, we'll have Liz Morgan talk about another issue related to family business succession planning, which I also believe is an outgrowth of a case that recently was decided. But Liz, you can correct me if I'm wrong when we get to that. Tom Miron here in the Syracuse office is here with us frequently to give NLRB updates, and he's here to tell us about a very significant update out of the NLRB. And finally, Colin's going to give us just a little primer about joint employment in New York. We like to do this occasionally, offer content that's not necessarily related to a new legal development, but just a concept that we think our friends and clients would benefit from knowing. Before we actually get started and we turn it over to Nick, I did want to just share one other tidbit. We didn't think this was worthy of a full 5 or 10 minute presentation, but I saw a news article last week that Governor Hochul has ended COVID sick leave for New York State employees. So I don't know if we have any sort of New York State agencies on here that this might affect, but just found it really interesting that the legislature decided to continue COVID sick leave for another year for private sector employers, but and I'm not talking about local government employees, but in terms of employees that actually work for New York State, COVID sick leave has been ended for them. So just thought that was really interesting move by the governor to, to make that decision for her own employees while we still have it for private sector. With that, just a fun tidbit. With that, I'll turn it over to Nick, who's going to give us this litigation update about the Chevron overturning and the harassment case. So thanks for being here, Nick.
Thanks, Kristen. So the first case that I'm here to talk about today is Loper Bright Enterprises and Relentless Inc. versus the Department of Commerce. In these cases, you might have heard referred to in the news more commonly based on the decision that they overturned, which, as Kristen said, was the Chevron decision. So both of these cases were companion cases brought by herring fishing companies, and they challenged actions of the Secretary of Commerce and the National Marine Fisheries Service in establishing an industry-funded monitoring program. And that program required monitors to be on fishing vessels to monitor overfishing regulations and other things of that nature. And it shifted the costs of administering that program onto the fishing companies themselves to pay for having the monitors on board their boats. Next slide, please. So in these cases, the Supreme Court overruled its decision in Chevron v. National Resources Defense Council. And that case established the Chevron doctrine, which applied where a statute was silent or ambiguous on a specific issue. If that was the case, the Chevron doctrine required courts to defer to an implementing agency's interpretation so long as that interpretation was permissible under the statute. And the court had to defer to the federal agency in interpreting the statute, even if the court itself interpreted the statute differently. So in this case, it would have been required to follow the interpretation of the Department of Commerce in ruling on the case. Next slide, please. So in a 6-3 decision, the Supreme Court held that courts no longer have to give deference to agency interpretations of statutes that they administer. And this was an extremely significant change in the law. The Chevron case has been cited over 18,000 times in subsequent decisions. So this really is a substantial departure and a very significant change, and that's one reason that we're hearing so much about it in the news. In overruling the Chevron case, the Supreme Court found that it was inconsistent with the Administrative Procedure Act, or APA, and the APA establishes the procedures that must be followed by federal agencies and also instructs courts on how to review agency actions. The Supreme Court held that the APA directs courts to decide legal questions in their own judgment. But what it does not mean is that the court can't consider the agency's opinion. The court still can consider the agency's expertise, practice, and the need for consistency in reaching its own interpretation on the statute. And it also allows for agencies to make policy decisions where they've been granted that authority by statute. Next slide, please. So why is this important? Many agencies rely on deference when adopting rules or deciding issues before them. And that would include a lot of agencies that our employers and businesses deal with, such as OSHA, the Department of Labor, and the NLRB. Now, challenges to those rules and decisions will be easier because the agency can't rely only on its own interpretation and showing that their interpretation is reasonable. Instead, the agency is going to have to demonstrate that their interpretation is consistent with the best interpretation of the statute. And if the court disagrees, their rule or their decision could be overturned. So the loss of that deference really is going to change the nature of litigation challenging agency rules and decisions. For instance, this change could affect current litigation with the DOL regarding overtime exemptions and independent contractor classification, with the NLRB over joint employment rules, and also with OSHA over a rule which allows union representatives to accompany inspectors, even in non-unionized workforces. So this is something that we certainly wanted to bring to your attention. The decision just came out late last week on Thursday, I believe. And it's something that I think you're going to be hearing more about potentially in next week's webinar. I believe a colleague is going to dive a little deeper into the effects of this decision, but it's something that we wanted to bring to all your attention and kind of give you a little bit of an explanation because we're sure you've been hearing about it. Next slide, please. Okay, so the second case I wanted to discuss today is MH versus Starbucks. And this case concerned a sexual harassment action commenced against Starbucks by a former barista under the New York human rights law. Starbucks made a motion to dismiss the harassment claims, among other claims. And in rendering its decision, the court considered whether the plaintiff had alleged sufficient facts for liability to be imposed on Starbucks for the harassment of its employee. And the standard for imputing liabilities for coworker on coworker harassment has been somewhat unclear since 2019, when you may remember there were some very substantial amendments to the New York human rights law. Next slide, please. Okay, so since the 70s, there's been a defense available to employers under federal law called the Farragher-Ellerth defense, and it applies under Title VII. And that defense applied where there was no tangible employment action against the plaintiff employee. So there was no discharge, demotion, suspension, nothing of that nature. It applied in harassment type claims. And it applied where the employer could demonstrate that they exercised reasonable care to prevent and correct harassing behavior and the employee unreasonably failed to take advantage of protective or corrective opportunities provided by the employer. So the classic situation where that defense applied was where an employer had an established harassment prevention policy, and that policy contained a reporting mechanism, and the employee failed to use that reporting mechanism to bring a report of harassment to the attention of the employer so the employer could correct the behavior at issue. There was a similar standard under New York law for the New York Human Rights Law prior to the 2019 amendments. And it was established in the case Forrest v. Jewish Guild for the Blind, which was a pretty important New York State Court of Appeals decision regarding the standards applicable under the New York Human Rights Law. And in that case, the Court of Appeals held that the employer could not be liable unless it became a party to the harassment by encouraging, condoning, or approving of it. Next slide, please. Then in 2019, the New York Human Rights Law was amended such that it included a provision that states the fact that an employee did not make a complaint about harassment to the employer shall not be determinative of whether or not the employer shall be liable. So it essentially undercut the Farragher-Ellerth defense. But the amendment was kind of interesting in that it didn't directly address the holding under Forrest v. Jewish Guild for the Blind that an employer can't be liable unless it condones, approves of, or approves of the harassment so as to become a party to it. So that kind of left that question open. And in the MH versus Starbucks decision, the Southern District of New York reaffirmed that the employer must condone, encourage, or approve of coworker on coworker harassment to be liable. Next slide, please. So how did the court apply that standard in that MH v. Starbucks case? There, the plaintiff alleged that despite Starbucks having received numerous reports of harassment by the coworker, who was a shift lead, so the coworker was somewhat, at least, in a position of authority, despite having those reports, Starbucks engaged in a pattern of failing to adequately investigate or discipline the employee. And in this case, the court held that the allegations were far from airtight, but sufficient to survive dismissal. Essentially, they held that the allegations were sufficient to show that the employer egregiously failed to take action despite the notice that they had of the coworkers' harassment of other employees, and in that manner approved of or condoned the harassment. Whether or not the plaintiff is able to prevail further down the line on summary judgment remains to be seen. So I think the important takeaways here for us as employers are there is definitely still value in having adequate procedures to prevent and remedy harassment among employees. And that can be a defense to liability if there is a subsequent action taken against us. So if we do the right thing when we get a report of harassment, that might be the basis of a defense down the line. But if we fail to adequately respond to reports of inappropriate conduct, an employee might be able to point to that failure as evidence that we condoned or approved of harassment, and it could open the door to liability. So I think that's a very interesting case for all of us to take a look at. One, because it clarifies the standard for employer liability for coworker on coworker harassment after the 2019 amendments. And it's also a good reminder that how we respond to reports of inappropriate conduct by employees could be critical in defending litigation down the line.
Thanks, Nick. Really helpful, really interesting. I personally am very excited about this Starbucks case. So really helpful. And we'll see you next month when you're back with your next litigation roundup.
Thank you. I look forward to it.
Yeah. Okay, great. So moving on to Liz Morgan, going up a few floors here in my building if you want to know exactly where we're located. Tell us about this new article that you just wrote for us, Liz.
Sure. Hi, everyone. Thanks for having me. My name is Liz Morgan. I'm a business associate here in Syracuse. And generally, what I do is I help companies and business owners and all their corporate needs with formation, dissolution, governance. I'm also a mergers and acquisitions, attorney. I assist both buyers and sellers and mid-market companies. And I also assist with business succession planning, which is why I'm here today. I'm talking about another Supreme Court case, which is Connolly. It's much more narrow in scope than Chevron, but it involves the valuation of small family-owned businesses and has a significant impact on business owners nationwide. And this was a rare unanimous opinion by the court. So what the court ruled on is specifically ruled on how life insurance proceeds and redemption obligations should be treated for federal estate tax purposes. Let's unpack that. Let me break it down by taking a few steps back. So as a general background, many small private companies are closely held with very few shareholders. Oftentimes, these shareholders are family members. And sometimes, upon a shareholder's death, these other shareholders want to keep the shares amongst the current shareholders or keep it in the family. They don't want the other shareholders to be going down the street and, bringing a stranger into the company. They want to keep it closely held. This is when the shareholders can enter into what we call a buy-sell agreement. A buy-sell can ensure that the ownership of the company continues on in a manner that's in the best interest of the company and fair to the owners by spelling out exactly what happens under different triggering events, such as death. For example, a buy-sell can state that upon the death of a shareholder, the other shareholder has the option to purchase the decedent's shares. Or it can also state that the company is required to buy back the shares, which is what is called a redemption. So either a shareholder can buy the decedent's shares or the company can take back the shares. In both circumstances, the shareholders stay closely held. So how life insurance proceeds come into play is that the company or the shareholders can take out a life insurance policy on the life of the other shareholders. Then, upon the death of a shareholder, the proceeds of that insurance can be used to buy out the stock and pay it out to the estate. Depending how the policy is set up, either the shareholders can use the proceeds to buy the shares and increase the number of shares, or the company can purchase back the shares in a redemption. This is a very common practice in closely held companies. I help draft buy-sell agreements fairly frequently. So this brings us to the Connolly case. Without getting too much in the weeds and the facts, essentially there were two brothers. They were each shareholders. They entered into a buy-sell. The company was valued roughly at $3.6 million, and the company had a $3 million life insurance policy on the brothers. One brother died, and per the buy-sell, the other brother, the surviving brother, did not exercise his option to purchase the shares. So as a default, the company was required to redeem back the shares using the life insurance proceeds of $3 million. So the estate filed tax on that $3 million because that was the purchase price. The IRS disagreed. The IRS stated that the insurance proceeds were actually added to the fair market value of the company. And the Supreme Court held this decision. So the tax liability went from $3 million, which was the purchase of the shares, to over $6 million, and thus increasing the estate tax significantly. So specifically, the estate tax value was not reduced by the redemption obligation. So it wasn't reduced by the obligation the company had to buy it back. So the takeaway here, if you had to do a takeaway, is that life insurance proceeds in a redemption is added to a valuation of a company and will increase estate tax. This case really underscores the importance of strategic estate planning for business owners. What can we do? Here are a few things we can do. Review buy-sell agreements in place. You want to ensure that these agreements are structured with tax implications in mind. There are also other ways you can structure these buy-sell agreements. Consider a cross-purchase agreement. What's the difference? This is where shareholders purchase insurance on each other. So rather than the company buying insurance on a shareholder, it's another shareholder buying insurance on the death of another shareholder. These insurance proceeds go to that shareholder to buy out that stock. It completely leaves out the valuation purposes of the business. That's another option. I would encourage also to review life insurance policies, analyze the impact of life insurance policies on the estate's valuation, and also consult with tax and legal experts. So that's all I have on this case. There's an info memo on this topic that you can access on my website bio. If you have any questions on this at all, I'd be happy to talk. Please don't hesitate to reach out.
Thank you very much, Liz. And Liz's contact information is right there if you do want to follow up with any questions on that. So our next presenter is Tom Huron, who, as I mentioned earlier, has been here many times to give us updates about NLRB cases. So I understand we have a case, Tom, that has now applied the CMEX decision being something we've talked about on this webinar before. Is that right?
That's right, Kristen.
Tell us about it.
I hadn't been on in a couple of weeks, and I thought maybe you had, when we had that burst of music, maybe you had introduced walk-up music.
It's a great idea, actually. I'm going to have all presenters pick a song from now on. Could be a lot of fun.
Okay. Good afternoon, everyone. Thanks for joining us. I'm pleased to be back. Kathy, if you could go to the next slide, please. I really want to talk about two developments in the National Labor Relations Act. The first one is a decision by the board to impose a bargaining order on the Red Rock Hotel in Las Vegas. So if we could go to the next slide, I'll give you a little bit of a rundown on the case. This started out as sort of a classic union representation case. So the union files its NLRB petition and note the date back in 2019, almost 5 years ago. A very large bargaining unit, 1,300 employees, service employees, mostly in and around the hotel in Las Vegas. The election is held 2 months later, and the union loses that election by a significant margin. The union files various unfair labor practice charges against the employer. The labor board does an investigation and goes into federal court before the board has adjudicated the case, before there's even a complete hearing. The labor board goes into federal court and gets an injunction against the employer remedying certain conduct. And we're going to talk more about the so-called 10J injunction in the second half of this presentation. But it was an element of the Red Rock case as well. After hearing, multiple days of hearing, we get a decision by the administrative law judge that gets appealed to the labor board. And last month, the labor board issues its decision. Now, the first thing I point out is it's almost 5 years later between the time that the election started and the board issues its decision. A great deal has happened in that 5-year period. And as Kristen mentioned, one of the aspects of this case that's significant is it's the application of CMEX. So let's talk a little bit about CMEX. And Kathy, if you flip the slides. Just as a refresher, back last year, August of 2023, the labor board came out with this decision, which we focus on employers who don't currently have a union, and the fact that this decision created a new framework under which, if the union filed or demanded recognition, whether they filed a petition or simply made a demand to the employer had 2 weeks to take action. And if there had been no petition filed, the employer was obligated to file that petition. So that's what was the focus at the time the case came out, in terms of those who did not have an ongoing union campaign and were looking to remain union free. The other piece of that case was the board taking the position that if there had been a demand for recognition and the employer committed an unfair labor practice or unfair labor practices, the board was going to dismiss any pending representation proceeding and award the union a bargaining order, place the union in as the representative of the employees as essentially as a penalty, as a remedy for the employer engaging in an unfair labor practice. That's the rule of law that exists today. It is on appeal to the Court of Appeals. And if you're following along with the timeline, you might be saying, well, wait a minute. The conduct of the employer in Red Rock occurred back in 2019, 2020. Even with the best crystal ball, you couldn't have imagined that the law would change in this way 4 years later and be applied to you 5 years later. But that's the nature of the law that we're dealing with. The Labor Board is going to apply the law as it exists today, even though the conduct may have occurred years ago. So what's the nature of the conduct in the Red Rock case? Kathy, if you'd flip slides. We've got some sort of classic unfair labor practices that the board found, confirming the decision of the district court and the administrative law judge. There was a substantial implementation of benefits that the employees had been advocating for shortly before the election, and some comments that the board found credible, where the employer indicated, or at least the board interpreted those statements as these new benefits would not be available to employees after the election. So there was a clear sense of this is what, according to the labor board, this is what we, the employer, offer you on a non-union basis. It's not going to be there if you unionize. And that's again, assuming that the board got it right in terms of the evidence, that's a classic type of conduct that is troubling to the board, impacts the conditions for a fair election. The case also has what can only be described as a Las Vegas unfair labor practice. The employer served free steaks to hundreds of its employees, and branded on the steaks were the words "vote no." In other words, vote against the union. I've never seen that in 37 years of practice. Buttons and T-shirts and hats that said "vote no," but never a delicious sirloin steak. So in light of these, what the board characterized as egregious unfair labor practices, it concluded that under CMAX that was a sufficient basis, the union having demonstrated its majority status at one point, demanded recognition at one point, again, back in 2019, here in 2024, the board imposed a bargaining order on the employer. In other words, we're not going to have a second election. We disregard the fact that the union lost the election, and we require the employer now going forward to recognize the union as the bargaining representative of all 1,300 employees and to bargain in good faith with the union. I've no doubt that the Red Rock Hotel will take this on appeal. And I would point out that while this is the first time the board has specifically relied on the CMAX rationale, It also, sort of in a belt and suspender sort of way, applied the prior standard, the GISO bargaining order standard, and concluded that the conduct here was so egregious that even under the prior standard, a bargaining order would have been appropriate. So that's the Red Rock case. Stay tuned as that develops. The second part of this discussion deals with the involvement of the court in the 10J injunction. And if Kathy, if you'd flip to the next slide. So, you know, we talked sort of offhandedly about a 10J injunction. What does that mean? Well, it's a reference to Section 10J of the National Labor Relations Act, which specifically authorizes the labor board to go into federal district court and seek an injunction from the court to protect the status quo while the labor board's process is ongoing. And we've just seen an example that the labor board's process is a multi-year process between the time a complaint is filed or charge is filed, a complaint is issued, a hearing is held, an administrative law judge rules, appeal is taken, and the labor board rules. Multi-step process can take several years. The Congress, in its infinite wisdom, granted the board the authority to go into court in advance of its final decision and seek an order to keep the status quo. And sort of the classic case is if you have a union organizing campaign and the employer fires the lead union organizing employee, and the labor board claims that that discharge was unlawful, it was motivated by anti-union animus, the labor board will seek an injunction to reinstate that employee so that the issue of whether or not he or she should have been terminated for cause or was unlawfully terminated gets resolved through the board process, and the individual is still in the workplace, able to engage in concerted protected activity. So in the Red Rock case and in the case cited here, Sachs against INSA, the labor board goes into court and gets an order that includes the obligation for the employer to recognize the union and bargain with the union on behalf of the employees. And if you're paying attention, you ask the question, well, how is that a maintaining the status quo? This was a non-union work environment. There may have been a petition to elect the union, but there hasn't been any demonstration through that process that the union is the majority representative. How does the court, the board conclude that an injunction is appropriate? And the answer is two-part. One is that prior to last month, there was deference given to the labor board by the courts in issuing these injunctions. And two, the board's theory is at some moment in time, the union had majority status and they demanded recognition, and the employer's subsequent conduct diminished that majority status, and we're trying to get a court order that puts back in time that moment when the union had majority status and was, in the board's eyes, the appropriate representative. It's a real thin reed, but cases like Red Rock and this INSA case are ones where the courts have deferred to the board. Again, as I said, until last month, where the Supreme Court in another Starbucks case, and reminiscent of Nick's discussion of the Chevron decision, was less willing than many courts and established a principle of less deference to the NLRB. And in particular, what the court said was a preliminary injunction of this sort is an extraordinary remedy. You really have to show that you're entitled to relief and that there will be imminent, irreparable harm if you don't get that injunction. And those same standards that apply in all civil cases where a party seeks an injunction apply to the labor board as well. The board reversed the decision and remanded the Starbucks case to apply this new, more rigorous standard to the board's request for an injunction. So where does that take us? Kathy takes us to the last slide. Clear evidence that the NLRB and their general counsel are continuing their aggressive push here, including using the courts for that purpose. Their decisions to date have made it easier for unions to organize and organize more quickly. And that means for all of you who are interested in maintaining a union-free work environment, you need to be ready. You need to understand where you may be vulnerable. You need to make sure that your supervisors are alert to potential warning signs. And most importantly, that from the top down, from the highest level manager down to the first line supervisor, that they're implementing the labor relations vision and philosophy and policies that you've put in place to recognize the value of your employees and encourage them to remain union free. With those thoughts, I'll pass it back to Kristen and wish everybody a wonderful holiday on Thursday for the 4th of July. Thanks very much.
Thank you, Tom, and I hope you have a nice 4th as well. Okay, before we jump to our last presenter, Colin, one quick thing. There are a couple questions in the chat about Liz's presentation, so I thought we could bring Liz back just for a sec to give some quick answers to that. Elizabeth, do you want to tell us what you see here in the Q&A?
Yeah, sure. So the first question was the applicability to LLCs. I was kind of talking about corporations, right? I was talking about corporations and shareholders, but yes, this is applicable to LLCs. It wouldn't typically be called a buy-sell agreement. It would be probably terms incorporated in an operating agreement. Oftentimes, operating agreements have restrictions of transfers, and you can have insurance or life insurance policies on different members in an operating agreement. So yes, it is applicable to LLCs. The second question was with respect to if the shareholders are trusts and whether that can, avoid some of the issues that Connolly presented. And so my short answer is no. I think that the issue is that it's when the company has the contractual obligation to purchase the shares. That's when the valuation of the company is increased and the estate tax is increased. You can hold another option. So I said that a way of getting around tricky valuation issues is you can have a cross-purchase agreement, which the company is left out entirely. This is agreements amongst the shareholders. The shareholders have taken out life insurance policies on each other. And so when a shareholder dies, you can the insurance proceeds are exchanged between the shareholders. Similarly, the insurance can be held in a trust. I've also worked with clients that have held insurance policy issues in a partnership. It's just as long as it's completely separate from the company itself, taking those proceeds and increasing the valuation. So that's my really short, complicated answer. And again, I would encourage you to reach out to me or anyone in our business or Trust and Estates Practice Group.
Great. Thank you so much, Liz, for jumping back on to do that. I thought that was an easier way than typing a lengthy answer. All right, Colin, sorry for that delay, but you're up now.
No problem.
Joint employment in New York.
Thanks, Kristen. So I'm the caboose, everybody. We're going to finish this train with some basics on employment law. And I want to talk about joint employment because it's something that I think we see quite often here in New York. And I'm often surprised by my clients who are surprised by the concept of joint employment and what it means and why it's been implicated in a particular situation. So, we think of the employment relationship as a binary one. There is a single employer and a single employee, and that's the standard relationship. But obviously in the modern workplace, There are lots of various entities that may have influence or some form of control over employees in a particular workplace. And that's why the concept of joint employment has become very robust, a theory and a doctrine that is used in various statutes where we get involved in litigation. And so it's important to have, I think, your radar on about whether or not you might be a joint employer in a particular situation, and what you can do to minimize any risk. So what is joint employment? Joint employment is, the concept is an employee is formally employed by one employer, but we can call that the primary employer. And in that circumstance, based on the facts of the setting, that employee may be deemed to be constructively employed also by another employer, the secondary employer, if that secondary employer exercises sufficient control over the employee's terms and conditions of employment. And again, as I said, no one is surprised that they are the employer of record for a particular employee. It's when that secondary employer often gets tapped on the shoulder and is said to have some kind of potential liability in the situation that people are surprised. What are the common joint employment situations? Typically it might be a situation where you have a primary employer and then a contractor or a subcontractor also involved at the work site. Very often it's a primary employer and a staffing agency who's sending employees to the workplace. It can also be a situation where you have a primary employer and a professional employment organization, the organization that maybe does HR, onboarding, training, payroll, those types of things as well. I have seen in my personal experience in New York, anytime there's been a staffing agency involved, an employee who's an employee of that primary employer, the staffing agency, but is assigned to a workplace, so is working at a place of the secondary employer, inevitably, in Division of Human Rights and EEOC cases, both parties will be named in the action. Now, that doesn't mean there's going to be ultimate liability down the road, but it is a potential in the circumstance. Now, as I said, there are various tests. I'm not going to get into the details of what those tests are, but the courts and agencies apply different tests to determine whether or not a joint employment situation exists. There are various tests under the Fair Labor Standards Act, that's for wage and hour matters, the FMLA for leave, the Title VII, as well as the New York State human rights law. So all of those are potential avenues for individuals to find a joint employment situation. I also want to just quickly differentiate joint employment from a related, similar topic, but different. And unfortunately, people use the two terms interchangeably, but there's joint employment, and then there's a concept called the single employer. That's where two nominally distinct entities effectively operate as one single unit, unified structure, or integrated enterprise. And that's more commonly the situation where, let's say you have a parent and a subordinate, or a brother and sister corporations. In those circumstances, again, collectively, they can be deemed to be one employer. Why is that relevant? Well, very often we see it in a circumstance where you're evaluating coverage. Maybe there's a large employer that has a large number of employees, but the subordinate employee, the sub or the side business, is very small and may not have a sufficient number of employees to be covered for purposes of, say, Title VII's 15 employee threshold, or the New York State WARN Act for 50 employees. In those circumstances, again, if you meet that single employer test, the two entities are combined such that they will qualify for coverage under the statute, and you'll have to comply with the law. What can you do? Obviously, the first thing to be sure is to be aware if you have a potential joint employment situation. Very often, I think I've seen employers, be surprised when a staffing agency and the primary employer are then combined or dealt with together in an action, because they felt that they've been trying to be hands off with the employee. But I've also seen situations where the staffing agency has been sending one or more of the same employees to that location. And the more that employer of record, the one at the work site, is doing things like assigning the employees to particular work sites, directing their work, imposing forms of discipline, doing some forms of training, providing any forms of, privileges like parking privileges, but some form of benefit privileges, you're going to be a joint employer, even though maybe the staffing agency is writing the paychecks, is providing the health insurance benefit. So really important to just be aware of that. And then it's also important, if you have these contractual relationships, either with a staffing agency or with a subcontractor or contractor, you really need to examine the indemnification provisions of those agreements. Try to understand what it means if litigation is brought. Are you going to have to, or is the staffing agency, for example, going to defend and indemnify any claims, even if you're also named, the employer is also named in the matter? Take a look at those agreements, make sure that they're as airtight as possible, and call your local bond attorney if you fall into any trouble with joint employment. It's an interesting topic, and we're happy to help you work through it.
Thanks, Colin. All right, well, that wraps things up for the day. Thanks for being here. Happy 4th, everyone. And reach out if you have any further questions. We'll see you back here next week. Bye-bye.